another key aspect to FCPA compliance with respect to private equity firms and their portfolio companies, and that is making sure that post-acquisition some form of a reasonably tailored FCPA or anti-corruption law compliance program, including policies on gift, entertainment, hospitality, facilitation payments, political and charitable contributions, as well as other types of policies, are implemented at the portfolio company. The existence of such a program would significantly assist the private equity firm in defending any allegations down the road that it somehow had knowledge of improper payments made at a portfolio company after the acquisition. Furthermore, the existence of such an FCPA compliance program is a key factor in U.S. law enforcement authorities providing cooperation credit or leniency to companies alleged to have engaged in bribery or other illicit activity. This cooperation credit or leniency is most recently demonstrated by the Department of Justice's decision to decline to prosecute Morgan Stanley for the conduct of its China-based employee for bribing Chinese government officials in connection with several real estate projects in China. If a private equity firm or its representatives pay a bribe to a foreign government official in order to obtain some favorable treatment, that is going to result in potential FCPA liability to the firm and the employee who engaged in the misconduct. That is a relatively uncontroversial point. The more controversial and less obvious point is that private equity firms may also face liability for the conduct of the companies that they acquire. This can arise in two contexts. First, it can arise in the context of successor liability, where a private equity firm can be held liable for the pre-acquisition conduct of a portfolio company. That situation is one that, while it exists, if it does come to light or is ever investigated by the law enforcement authorities, there would be good factual and legal arguments to make against the imposition of successor liability. Although it's important to know that the DOJ and, where applicable, the SEC seek to impose liability under the successor liability concepts of federal law. The liability of a private equity firm would be based either on the knowledge of the firm or its employees of the misconduct by the portfolio company, or would somehow be based on the authorization, direction, or control of that misconduct by the private equity firm or its representatives. Significantly, where a private equity firm does not have an active management or day-to-day operational responsibility for a portfolio company, a good defense would be available that the private equity firm did not know or was not otherwise in a position to authorize or direct the misconduct. Nevertheless, U.S. law enforcement authorities are keen to investigate not only the wrongdoers but also their parent companies and investors for participation and involvement in wrongdoing. One of the ways to prevent such liability is to conduct pre-acquisition due diligence on portfolio companies. This due diligence can take many forms, but would generally include issuing questions to the portfolio company about its government official interaction, its government customers, and its interaction with foreign governments in connection with obtaining permits, licenses, or other types of concessions or benefits from the foreign government. Furthermore, diligence of any portfolio company in the pre-acquisition context must be informed by the jurisdictions in which a company operates. A private equity firm would be well defended if it took an approach that is somewhat less stringent for a company that does not have any government contracts and does not have much government interaction and operates in jurisdictions not known for corruptions than it would be if it took the same approach for a company that has operations in jurisdictions that have significant government interaction, significant government contracting, and located in jurisdictions that are known to be corrupt or have a prevalence of corruption.